great to be here, and it's just been an awesome presentation so far. So I'm here to talk to you today about the right to be forgotten and the implications for evidence and truth, which is a great theme of the conference. So I'm here to talk to you about the recent European Union General Data Protection Regulations, referred to GDPR. So the European General Data Protection Regulation, referred to, which I'm going to be referring to as GDPR, is designed to protect the privacy rights and freedoms of individuals residing in the European Union. And this regulation will take effect in May 25th, 2018. Yes, so I see there are people hearing the other presentation like I am in their ear. It's not a bother. Okay, I'll continue. So really, you only have to look at the recent Facebook and Cambridge Analytica scandal to understand why a regulation like this is so important. So the GDPR regulation applies to the privacy and protection and processing of personal data of EU citizens' residents, regardless of where the information is stored. So as a result, this regulation is impacting organizations globally. So the regulation, GDPR, was developed to sort of reflect the changes to the way business is done in an interconnected and virtually borderless world that we're living in. So GDPR provides protection to European citizens no matter where their data travels. So this means that any company anywhere that has, say, like a database that includes EU citizens is bound to its rules. So therefore, it applies to non-European companies. And this includes those in the US. So if you can imagine, you know, virtual web-based companies who are, you know, operating globally, you are going to be need to be compliant with GDPR regulations. What is really interesting about this new regulation coming out of the European Union and why it is receiving so much attention outside of the EU is that it, as you know, from a data governance perspective, GDPR is expected to set the standard for all privacy regulations globally to follow. So GDPR is going to be the new data privacy norm. But what is scary about GDPR is that European supervisory authorities, or what are we know as regulators, can fine organizations $20 million euro, or 4% of their global annual revenue for any violation. And this is what's changing the scope of privacy regulations, is this new penalties. So GDPR is comprehensive regulation. It covers 99 plus articles, which include provisions about client consent, data breaches, data processing, data security, and individual subject rights, which, you know, I've highlighted there because that's going to be sort of a little bit of the focus of my conversation tonight. So under the new regulation, which again, global ripple effects, subjects, or what the regulation is called subjects, but really it's people, have the individual rights, including the rights to access their information, correct their information, restrict the use of information, and to erase their personal information. So my goal tonight really is just to introduce you really quickly at a high level to the individual subject right to erasure, also known colloquially as the right to be forgotten, which is Article 17 of the regulation. So in order to be GDPR compliant, organizations must not only handle consumer information carefully from a data perspective, protection, but they must also provide consumers with ways to control, monitor, check, and if desired, delete the information pertaining to them. And so in keeping with the theme of this conference, where we're talking about trust and trusted information, as records and information professionals, we have to ask ourselves the question, does the individual subject right of erasure really challenge the notion of records serving as documentary evidence and truth for organizations and society as a whole? So I will just introduce that concept to you, and we can always follow up further with other discussions. But really, the right to be forgotten is really not new to GDPR. In fact, and this is what I want to share with you, is there's a well-publicized EU Court of Justice decision that happened in May of 2014, which really solidified the right to be forgotten as a human right in the court case of Google Spain versus Gonzalez. And I will get to your question that I just see popped up. So Mr. Gonzalez, this is just one example of a court case, and it was probably the most famous because it was one of the first, is Mr. Gonzalez brought a complaint before Spain's Data Protection Agency, and in which he essentially argued that content on the web referencing himself in a legal dispute, which was really in a newspaper, should be removed because the legal proceeding referenced in the newspaper concluded years ago, and there was no outstanding claims against him. But this information in the newspaper on the legal complaint was being indexed by Google, and was being displayed in searches against his name. So he brought this claim forward, and so the EU court ruled that a search engine in this case is regarded as a data controller under the EU regulations with respect to the processing of personal data, and in its acting when it's locating and indexing and storing and disseminating information. Additionally, in that way, in that order, it has to guarantee the rights and privacy and protection of the personal data as it operates as a search engine. And as a result, it can be required to remove personal information published by third-party vendors. In this case, it had to de-index that information. So this outcome of this ruling, again, which is really interesting, is that Internet search engines must consider requests from individuals to remove links to freely accessible web pages resulting from a search on their names. The grounds for removal include cases where the search results appear to be inadequate, irrelevant, excessive in the light of time that has lapsed. And so since 2014, Google accepts requests, and you can go to their online form in the EU for removal of such links. So while data erasure is not new to GDPR, the new regulation that's coming into effect really just strengthens the principle and improves the legal certainty of the right, which the new regulation essentially does is really details, it broadens, it defines the scope of this right to be forgotten, making it a fundamental data subject right, requiring companies and social media platforms to enable EU citizens to exercise this right. So the rule is very clear in that, data subjects or data persons shall have the right to obtain from the company the erasure of personal information concerning him or her without any undue delay. And undue delay is considered 30 days. So specifically, it says that personal data can no longer be required for the purposes for which it was originally collected. So So let's get into the crux of this, is that critics contend that the right to be forgotten stands in conflict with freedom of expression and freedom of speech, and can lead to censorship and sort of this, as archivists and historians, some of us in the room, this revisionist history and the right to memory. So it's, and I don't want to stand in front of you, and it is important not to sensationalize or aggregate or overstate the right to be erasure or a right to be forgotten. The right of erasure is not absolute or unconditional. It does really have exceptions and limitations. So, for example, an individual cannot request to delete data if, say, there is a legal or regulatory reason for which it should be retained. And for us as records and information managers, a company has also competing clear legal and regulatory obligations to keep records for maybe tax acts or anti-money laundering reasons, or there's legal and regulatory reasons why we need to keep personal data to act and process you as a client. Also, a company is exercising their also right to freedom of expectations and freedom of expressions. And companies also need to keep individual privacy information to carry out tasks that are in the public's interest, especially in the interest of public health. And also, companies are allowed to archive individual personal information for, again, public interest, for scientific or historical reasons, or for statistical purposes. And personal data can be kept if a company needs to keep this to defend themselves about an ongoing legal claim. So I say all of that to say that there are legitimate exemptions to the right to erasure. So also, that's being challenged with this regulation is the complexity of the rules execution from a practical perspective. It is also being called into question, especially in our current digital landscape. And you've heard Dr. Franks talk about blockchain. Blockchain is, essentially designed not to delete certain data. And also, as we move towards more artificial intelligence, big data, and cloud, these tools are designed to collect and store and save and process information and large amounts of data. So how could you really truly delete information from these environments 100% if required to do so? So again, this is interesting times. So we really are as information professionals, we need to think about exercising the right to be forgotten and understanding that it's complex and probably needs to be done at a granular level, looking at the impact of this on various technologies at a case-by-case level, including the potential of overriding legitimate grounds, as I just talked about earlier about legitimate means to retain this information. So the right to erasure or the right to be forgotten is an area where there's going to be no black or white answer on what must be done. And every organization, every record, and every piece of technology used will be required to analyze this on a case-by-case basis. So obviously the right answer is balance, or the need to counterbalance freedom of expression, public interest in the information, and the individual's right to privacy. Again, a case-by-case assessment is needed, considering the type of information in question, its sensitivity for the individual's private life, and the interest of the public in having access to that information. So to conclude, the right to be forgotten debate is far from resolved and possesses difficult questions about access to and the control of information, of digital information across our virtual national boundaries. And it appears that the debate on the rights of EU citizens and beyonds will not really even be be solved as this new rule takes effect in May. So this is just interesting to me, and it's going to be an interesting item for us as information professionals to follow. So thank you.